Good afternoon, everyone, and welcome to Manchester. I'm Işıl, and it's a great pleasure for me, on behalf of Wilde, to introduce the opening discussion of this year's ESIL annual conference. Wilde, the Women in International Law Network, was founded in 2016 by the women researchers of the Manchester International Law Centre. It aims to promote the place of women working in international law and provides a much-needed platform to exchange ideas and share experiences. Wilde is a platform for discussion where female international lawyers share their experiences in the field through networking events, podcasts, blog posts, or interviews. It's apt that such an initiative was launched at the University of Manchester, where Professor Gillian White, the first woman to be granted a professorship in a law school in the mainland UK, held an appointment, and where Christabel Pankhurst, suffragette and co-founder of the Women's Social and Political Union, obtained a law degree. The inequality between women and men in academia is indisputable. Despite considerable improvement in women's representation in recent years, women still occupy a disadvantaged place compared to men. According to the Higher Education Statistics Agency, while women occupy 46% of the academic workforce, women hold only 24% of professorships in the UK. There are several reasons why women do not share an equal standing with men in the academia. Women academics devote more time to teaching, mentoring, admin work than most men. However, success in academia is measured mostly by the number of publications. This definition is inherently problematic and omits several factors that should also be considered part of the academic work. The wage gap, bias in student evaluations, all-male panels, problems related to maternity are only some of the other issues women have to deal with to work on an equal basis with their male colleagues. We are also aware that this problem of inequality is intersectional. Class, color, sexual orientation, disability, and gender are all interconnected. Together with the interest group on feminism, we had very lively discussions this morning about how to overcome these issues. In spite of all these injustices, some women made great advancements in the feminist movement. Today, we have the immense privilege to welcome Professors Chinkin and Hilary Charlesworth, whose works on international law made the world a better and safer place for women. Professor Chinkin is the founding director of the Center for Women, Peace and Security at the London School of Economics. In 2000, her co-authored groundbreaking book with Professor Hilary Charlesworth, The Boundaries of International Law, a Feminist Analysis, examined the status of women in international law. In 2005, in recognition of this and other contributions to scholarship, they were awarded the American Society of International Law Gowler T. Butcher Medal for outstanding contributions to the development or effective realization of international human rights law. Professor Chinkin has been a consultant and advisor to UN bodies on a range of issues, including human trafficking, gender-based persecution in armed conflict, peace agreements, and violence against women. She is the leading expert on the UN Convention on the Elimination of All Forms of Discrimination against Women. She was the scientific advisor to the Council of Europe committee that drafted the Convention on Violence Against Women and Domestic Violence. Professor Hilary Charlesworth is a Melbourne Laureate Professor at Melbourne Law School and also Distinguished Professor and Director of the Centre for International Governance and Justice in the Regulatory Institutions Network at the Australian National University. Her research includes the structure of the international legal system, peace building, international humanitarian law, and feminist approaches to international law. She has worked with various non-governmental human rights organizations on ways to implement international human rights standards. She was chair of the Australian Capital Territory Government's inquiry into a Bill of Rights, which led to the adoption of the ACT Human Rights Act 2004. She is an associate member of the Institut de Droit International and served as judge ad hoc in the International Court of Justice in the whaling in the Antarctic case. She was appointed by the Australian government in 2015 to a second term as a member of the Permanent Court of Arbitration. We also welcome Ralph Wilde, who will be moderating the panel. He works at University College London and is an expert on administration of territory by international organizations and the concept of trusteeship in international law. He also works on refugee law, the law and practice of colonialism, occupation, state building, and post-conflict reconstruction. His monograph, International Territorial Administration, How Trusteeship and the Civilizing Mission Never Went Away, won the Certificate of Merit of the American Society of International Law in 2009. In 2010, the Leverhulme Trust awarded him a Philip Leverhulme Prize, which is given to UK-based academics under 40 who are judged to be outstanding scholars who have made a substantial and recognized contribution to their particular field of study, recognized at an international level. Before I pass the floor to our discussants, I'd like to mention that the Boundaries of International Law, published by the Manchester University Press, will be sold for a discounted price of only £10 during the first 24 hours of the conference. Professors Kirsten Chinkin, Hilary Charlesworth, and Ralph Wilde, thank you very much for traveling to Manchester for the opening discussion of this year's annual conference.
Well, as a proud Mancunian myself, I would like to add my own voice to the welcome to all of you here to my city. As we all know, here in the UK and Manchester, we are commemorating this year the centenary of the Representation of the People Act, which gave certain women, as well as certain hitherto excluded men, the right to vote. And Manchester was at the vanguard of the suffragist movement, with the Manchester Society for Women's Suffrage being founded here in 1867 by Lydia Becker, its first secretary, and others. And of course, one of the leaders of the movement, Emmeline Pankhurst, was born here in Moss Side and engaged in activism here. Now, much, of course, has happened in feminist thought and activism over the past century in the UK and internationally. In our field, eventually, somewhat belatedly, feminist ideas started to enter the international legal scholastic canon, due in large part to the foundational seminal work of the two women I'm privileged to be with here today. What we might call the Lydia Becker and Emmeline Pankhurst of international law. And again, Manchester played an important role here with their monograph, as has been mentioned, The Boundaries of International Law, being published by Manchester University Press. Just as then the centenary of the vote for certain women in the UK has led to reflections on the state of women's rights in this country, so too the 20th anniversary of the publication of the Boundaries book is a good moment to reflect on the state of feminism and issues of gender internationally, notably in international law. So I'll be asking Christine and Hilary a series of questions to prompt their reflections here, and then we'll turn the floor over to you for your questions and comments. So first of all then, what does feminism mean in the context of international law?
Thank you, Hilary. Thank you very much, Ralph, and for the earlier very warm introduction, and to the conference organisers, Jean and Ian, for inviting us. And I would also like to say we ought to remember Shelley, who began this journey with us, Shelley Wright, with the article in the American Journal of International Law that came before Boundaries. So that's all avoiding what does feminism mean in international law. For a start, of course, it's feminisms. in international law. Multiple feminisms, multiple women's voices from many different jurisdictions, geographic space that was talked about earlier, many different political, religious, other persuasions. But perhaps on reflection, what is unifying is that it involves a curiosity about women's lives, and a curiosity about women's lives from a, words of one of my colleagues, a transgressive engagement point of view, a curiosity that is directed towards opening up spaces to challenge why the legal system, and the international legal system in particular, fails to take account of women's lives and the various gaps, conceptual ambiguities, and other ways in which women's lives are discounted, and leading to, and it's clearly also a political agenda as well as a legal agenda, the notion of equality, but not just an equality with man, the whole debates around male comparators, etc., but what we might call a transformative equality, an equality that challenges the structural biases that maintain inequality. Hilary, over to you.
Can I just start by also echoing the thanks to the conference organisers for their invitation and to the lovely introduction, so thank you very much, and also from Ralph. I also just want to say that I said to my daughter, who I think had just been born at the time, that about just the year before our first article was published, I said, well, I'll be away for a while. I had to apply for relief from grandmotherly duties, and I said, I'll be away for a while. And she said, where are you going? I said, oh, well, to a conference. And she said, what are you speaking about? Feminism and international law. And she just looked shocked. She said, Mum, haven't you got there yet? And so
are we still talking about it?
So in a way, I sort of feel with the 20th anniversary of the book coming up, and I thought, well, yes, you can get a cheap book or a cheap beer. So that'll be, we'll see which one sells better. I feel in a way, I sort of want to start off by sort of noting that in a sense, it seems funny. I feel that Christine and I are here in this privileged position of having this captive audience by virtue simply of our longevity. I think we feel in lots of ways like the dinosaurs in a sense of feminism in international law, partly because what does feminism mean? In a way, what we were trying to do in the book has been so wonderfully and richly outstripped by the work of so many colleagues who've taken on feminism in international law. And I know just from this morning's wonderful session that there are many in the room, these brilliant generations of scholars who've just taken feminist ideas and often with no reference to us, but have built up an amazing and diverse sort of whole body of scholarship that's incredibly important. So I feel it's important just to say that what we were talking about in the book has been very readily outstripped by the much more interesting scholarship that I think has come from many others. But in a way, I think we have to understand feminism in international law, and the curious thing about it and the vulnerable thing about it is that it's both a political ambition, I mean it has a political message, in the sense that it's interested in inequality and challenging universality, to borrow from Jean's very rich talk, but it also claims to be an intellectual method. So it's very interesting, I think, in the sense that those two, the political goals and the intellectual goals, can sometimes be in tension. But I'd just say very broadly that in a way, what does feminism mean in international law? Well, first of all, it means paying attention to the position of women. Where are they? Where are they present? Where are they absent in international law? This would raise issues that scholars like Stephanie Vauchez-Ennet has written about, Ennet Vauchez, I should say, very interestingly in the European Journal of International Law, about where are they on the European Court of Human Rights and so on. There's a whole body of scholarship there. But the questions of feminism go much, much broader than that. Not just where are the women, what's happening to them, but most crucially, it draws attention to the role of gender. not meaning men and women at all, but the social construction of male and female roles, and the way that this actually is embedded in the structure of many international legal norms. So, in a way, arguing that international law is a gendered discipline is, of course, a challenge to its objectivity and also to its universality. I think the really big issue for feminist inquiry in international law, they echo many of the problems that Jean d'Aspremont has just guided us through in talking about universality generally. How can we speak a universal language in a way that's productive, or must we be constantly brought back to particularities? And I think feminism has had to feminism in international law has had to deal with that because there's a significant body of work, especially from third world approaches to international law, that 12 groups of feminists who've really raised very important and challenging questions about the nature of feminist inquiry in international law.
Can I just come in, though, on one point that I think we talked about earlier as well, which is, I think both of us, and correct me if I'm wrong, see ourselves as primarily international lawyers, and international lawyers who are very concerned about all the issues of feminism that you've just talked about. And we really sort of try to see how can those ideas be brought in as international lawyers, rather than feminists who happen to do international law. Yeah, it's sort of that way around.
Yeah, I think we often talk about this. We're very conscious that we don't have any academic grounding in feminist theory, and we both started our careers. I remember imagining that international law really did deliver on its objectivity, its impartiality. And I think it took us, they weren't ideas that were around when we were students or even when we were young academics. And we see ourselves very much as, if you like, primarily international lawyers who perhaps borrow feminist ideas and borrow them sometimes in a not particularly coherent way.
Well, Hilary, you mentioned TWAIL. As we know, the Representation of the People Act here in the UK gave votes only to women who had a certain property classification, either themselves or via their husbands. And this, as well as the higher age of 30, excluded 5 million working class women from that reform. And this issue of class is, of course, foregrounded by the symbol of the bee, which is on all your bags for this conference, a symbol of Manchester University, which represents in this city the workers of the mills. But this in turn, of course, requires us to, as so often isn't done in this city, to acknowledge the link between the cotton industry of the mills in Manchester and British imperial and colonial domination and exploitation, which of course enabled the plunder of cotton that was then brought here to be spun in the mills. So just as Manchester's central role in the Industrial Revolution that's already been mentioned was enabled by colonialism, so too, however, this city hosted important anti-colonial meetings. Most notably, the 5th Pan-African Congress was held here in 1945 with delegates from across Africa, Europe, and the Caribbean, including figures who would go on to lead their countries on independence, such as Jomo Kenyatta and Kwame Nkrumah. So now in our current Rhodes Must Fall woke era, what we now refer to as intersectionality, linking issues of gender to race and class, has become much more prominently acknowledged. Symbolized here perhaps by a more intersectional worker bee. Some of you walked past on the way from the train station. So my next question would be then, how then did you and do you approach intersectionality in your feminist work? And how well do you think it has been appreciated in the canon of feminist international legal scholarship?
So again, again as a side issue before sort of thinking about directly about our feminist work, Some of us, someone in the audience, went earlier this week to a new show that's on in London called Sylvia. And Sylvia is about Sylvia Pankhurst, who is often the Pankhurst sister who is not remembered in the same way. And I mean, what was really interesting was how she refused to celebrate 1918 precisely because of the exclusion of the working class women that she was then working with in the East End of London. And so the linking of the East End of London up again with Manchester, other areas of the industrial part, and how, as far as she was concerned, the battle wasn't won for at least the next 10 years until 1928. So the sort of split between different feminist groups and the fact that very much it was portrayed as Emmeline and Christabel essentially fighting for votes for women of their class. Not the broader. And it was a good show, wasn't it? Looking at those that we went together with. How have we addressed it in our own work? It's a very challenging, clearly, and I think it's something we've struggled with constantly from the very beginning. As John put it earlier, only we'll change the gender, white, middle class, privileged women. How can we encompass that much broader and that much more rich and diverse voices that are necessary to make any real impact into international law? I think perhaps just two responses I would make. I was thinking back to one of the first sort of experiments with feminist methodology that Shelley Wright and I made in an article which was, 25 or so years ago, about freedom from hunger. We called it the hunger trap. And in that, what we did was tell stories. And so we used the feminist methodology of storytelling and used storytelling working from documents of women's own voices. And so trying to bring a range of women, I think it was 7, what I remember, and how issues relating to hunger and poverty impacted differently on, for example, an Australian Indigenous woman, on a woman in war-torn Somalia, and on women in rich Western cities, and how at different stages and different ways the impact or otherwise of international legal engagement how it failed them in most ways, but how it was building also on Isabel Gunning's world travelling idea, this idea of trying to look at different narratives, different stories, different ways in which what Hilary has just called, the gaps and inconsistencies, how do they actually play out, and what might be the appropriate ways of trying to address what was at root a common issue around hunger, around what food meant in these women's lives, but coming at it from these diverse perspectives. As a more recent example, and you also raised about how such issues have impacted in other feminist work. There was in 2015 a global study that was carried out by a wide group of women chaired by Radhika Kumaraswamy from Sri Lanka, essentially looking at where the project that had commenced back in 2000 in the Security Council, Women, Peace and Security project, where had that got to by 2015. And Radhika describes the consultation that was taking place to make sure that it is a multiplicity of voices. And I think the strongest message that came out of that consultation was that she said it was heard over and over and over again across race, class, ethnicity, sexuality, and so on, that the overwhelming message was no to militarization. In other words, a view with respect to end of conflict, end of the power hierarchies of the Security Council, an absolute message of peace without the militarization. And I think that's a really good example of how feminist working, the cooperation, the methodology that was engaged, and the final message were coming across from so many different places.
Yeah, I also just add quickly that I think one one way is to be very conscious of one's own position. And I think that's something we've certainly tried to do, not always, I think, successfully, but we've always tried to acknowledge the fact that even being able to theorise in the way that we have, or the luxury of being a scholar, you have to have a very particular sort of life to be able to do that, and that implies immediately a certain amount of privilege. Simply the life of a scholar is a very privileged life. But I think to be clear about your own position, and also to be conscious of alternative perspectives. This was brought home to me very, very much when, with an ANU colleague, John Braithwaite, we did a study of Timor-Leste, of the birth of Timor-Leste, and spent a lot of time interviewing women's groups there, and to find out how they had, or what were the norms that they thought they had brought to bear in that context. And one thing that was very striking was the fact that international law that we're very used to deconstructing and criticising, but a lot of the women's groups in Timor-Leste regarded international law as unbelievably significant in their struggle. And so it was also very, I guess, grounding to realise something that we'd like to unpick and say there are problems here and they're gendered here and they're gendered there. A lot of the women's groups said, yes, that may all be true, but they've actually been really powerful as discursive tools in our struggle. And even today, a lot of the women's groups in Timor-Leste, the fact that Timor is a party to ESIL, the ESIL Convention, as flawed and as problematic as it is still regarded as quite a potent political tool. So I think being aware of one's own position and noting that up front is one technique to acknowledge the issues of intersectionality.
Thank you. So now I'll combine two questions before then asking about the future. And so I'm wondering if you had any particular areas where feminist analyses in international law have had an impact. What effects in particular you can identify? What would be, as it were, the key developments that you've seen?
Hilary should start first this time.
I mean, just a point, because I know that you're trying to wind us up, so that we. I would just want to say, I think that where feminist discussion in international law has had an apparent success is getting some feminist vocabulary into international law, some, very limited. So the idea that sometimes the word gender has made its way, for example, into the statute of the International Criminal Court. We have Resolution 1325 of 2000 for the Security Council. So what happens is that you get some references to women and gender sort of sprinkled about in international law, and some people take this as a great success. What more do you feminists want? I'll show you these references, or we have the Istanbul Convention. But what's very, very striking is that in a way the international system seems to have been quite adept at absorbing the vocabulary, but then of normalising it and of stripping it of any radical potential. And I'd just refer briefly as an example of that to the whole project of gender mainstreaming. There's a gender mainstreaming industry in international institutions. This is accepted. It's on the websites of everything from the WHO to UNESCO. We all do gender mainstreaming, but all the empirical studies of what is this doing, it's minuscule. And it simply means just really adding a few women and stirring and hoping that there will be change. And so I think that there's been, yes, some successes in terms of vocabulary, but in fact, I think the international legal system has remained remarkably impervious to any form of deep-seated feminist change.
Just scared to pick up on a couple of the points. You mentioned the word sort of gender mainstreaming as an industry. I think there's been another industry which has been the inclusion of women in various positions. So we now have this range of bodies of gender advisors, women protection officers, teams of gender experts that are sent out to UN missions, a whole range of new institutional positions, which again, on the one hand, brings women in, makes them visible, puts them into these various positions. But it's not been accompanied by either any theorizing about women and gender. Within, I think, so much of the international institutional framework, gender means women, and women equates special needs and responding to those special needs. But nor is there any real consideration about why it is important to have women. And if I go to another talk, usually by the British Foreign Office, that says it's the smart thing to do, and that therefore justifies totally, I think I will scream. There's this sort of instrumentalization type argument without in any way at all looking at what is it that is being sought to achieve by including women? What assumptions are being made there? What characterization, is it women as peacemakers or women as helping this civilizing mission in some way or another? And are these women being asked to do the job that their male counterparts are being asked to do, and the extra that's being requested because they are the women who have been put into these particular places? Have these women ever been consulted about what it is that is being understood? And to go back to the Women, Peace and Security resolutions, which are full of the words participation. 1325, the original Security Council resolution on women, peace and security, essentially makes participation and mainstreaming the two main goals. Nowhere at all does it actually talk about, well, what is it? Why? And I think very conspicuous by its absence is the idea that this is simply a matter of gender justice, equality, fairness, rather than being an instrumentalized. And it seems to me that where women are brought in is either instrumentalization or it's co-option over and over again.
Can I just add, I think we also need to note that with all these developments, and I think we would agree that they have been rather meagre and problematic. But what's very, very striking, I think we see this increasingly in international law, is that there's been a huge backlash to them. So perhaps as disappointing as they might have been to the feminist movement, they have nevertheless caused a lot of angst and have become women's rights. And talk of women's rights now have become really a stalking horse for a number of different conglomerations of conservative movements, very powerful movements in countries. So we see, for example, just to give an example of that, we see at the Human Rights Council, for example, the increasing, there was first of all the attempt to define a category of traditional rights as opposed to human rights, which were very much, the traditional rights were very, very much associated with very narrow conceptions of sexuality and so on. And now we have at the Human Rights Council the great attention to protection of the family. The family has now become this precious entity that needs protection without enough attention to rights within the family. So we can see that even what seemed like quite puny or very modest acceptance of the vocabulary of feminism in international law, it nevertheless there's been a very strong movement against it. And I think this, with the increase in populism and so on, we're seeing that increasingly to be spreading. So I think it's sort of quite a difficult and challenging time for those with an interest in feminism and international law. And
to come in on that again, the very language of rights, so that the sort of whole move around CEDAW, the Vienna slogan of women's rights are human rights and so on, what we now see is that gender equality is included as one of the first Millennium Development Goals, now the Sustainable Development Goals. And so Sustainable SDG number 5 is gender equality. Okay, important and so on, but that language moves it away from the language of rights and the language of obligation, entitlement, and state responsibility. State responsibility for compliance with rights and for accountability if there is a violation. Put it into SDGs, it becomes a matter of politics, a matter of allocation of budget, a matter of indicators, a matter of technical ticking and so on, and away from that important aspect of rights and obligation. And I think that, so we have on the one hand backlash, and on the other hand weakening, euphemism, moving away in the so-called name of progressive language. You can see we're getting cross.
Well, perhaps now is the opportunity to open the floor. We haven't got much time, so it'd be great to hear your questions and comments. Please, if you can state who you are, where you're from, and please keep what you have to say brief, just to give as many people the opportunity to contribute. We'll take a collection of questions and comments in one go, and then come back to Hilary and Christine for responses. I'm afraid that's all we'll have time for. I've been given special dispensation to go a few minutes into the coffee break, but we can't go further than that. Okay, so who'd like to kick off?
Thank you very much, Christine and Hilary. Mary Footer from the University of Nottingham. I have a very simple question because I'm roughly the same age as you. So I'm looking back also over about 25 years of academia and practice, and I'm wondering, do you think that the role of feminism in international law, do you think that's had an impact on women? Do you think that younger females entering either the academic world or government practice or the judicial system are better off today? Have they been influenced? I'm not saying influenced by your work necessarily, although I hope that's the case, but do you think it's become easier for them? And if not, what are the current hurdles? What are the challenges or the hurdles that remain? Thank you.
Thank you. Philippa, over here.
Philippa Webb, King's College London. Just on Christine's last point about this weakening in the name of progressive language and the SDGs, how would you see gender equality through a lens of state responsibility?
Maria Smirnova, Milk and OHCHR. I was just wondering, again, picking up on the same topic, SDGs are a temporary project. And I understand your criticism that the language tones down obligations of states in terms of establishing women's rights as human rights. But at the same time, it's temporary, and it mostly aimed at those states which are probably in the beginning of their way to ensure women's rights as human rights. And they may need, or might need, maybe more straightforward language for this, and indicators and all the technical tools to help start this journey.
Thank you.
Yeah.
Yes, up there at the back.
Thank you. Erika de Wit, Universities of Pretoria and Bonn. To both presenters, have you over the last 15 to 20 years experienced within academia, the institutions in which you've been involved in, a progressive or a regressive change in institutional culture? Because there is often an emphasis on numbers and appointing women so that we have our few trophies. But an increasing number of trophies, but then how, if at all, has the institutional culture adjusted with this, and what needs to be done, in your view, to enhance further improvement? Thank you.
Maybe one more. There is. Yes.
Thank you. My name is C.S. Pilopoulou Åkermark from the Åland Islands Peace Institute. I thought the account you gave of Radhika Kumaraswamy's assessment concerning putting ahead issues of the non-remilitarization was extremely interesting, in a sense putting the feminist claim behind the claim of the remilitarization. How do you see this heading now, today, and what are the strategies of feminist international law in this increasing trend of remilitarization?
Great, thank you very much.
Yeah, that's an impossible question.
Hilary.
Well, I'm going to leave all the difficult questions to Christine because I think they're all addressed to her.
But we agreed the topics together.
Just perhaps Mary's question, which if I can summarise it, is what's the situation for younger women today coming into the international law careers? It was very interesting and I would say sobering this morning listening at the interest group, because one thing that we heard from, Christine and I were both remarking, we heard from a lot of women who were actually academics mainly, they're doing PhDs and lectures and so on. We heard many stories about how difficult it was to do feminist research and so on. So I think that we might divide. I think that perhaps things are easier for women generally. I think there is more, perhaps more attention in institutions, an understanding that a monolithic white male cadre is going, there might be some problems, there's something wrong with that picture, but the sense that women were mainly tolerated when they stayed in their place and stayed with subjects that might be expected of them. But what we heard from our colleagues this morning was the tale that if you wanted perhaps to do feminist research, work in queer theory, ideas that seemed more transgressive and more disturbing, this was still really difficult. And I think we were just saying that over lunch. We found that quite surprising. I do recall a colleague who was once told, and I thought this was very much in the past, 30 years ago, for a promotion application, look, better leave off any of your publications that have feminist titles. Leave them off your CV because this will seriously prejudice your application. I won't give the name of that person who survived to be promoted, so that was something I was used to then. What we heard from our younger colleagues today from a range of universities, not just in Europe and so on, was very, very striking. So I think the at the moment, the space for feminist thought is still quite closed. On the other hand, to be more optimistic, I think that with the organisation of women's groups, I think like the network that's got its life here at Manchester, and with the Feminism and International Law Interest Group of the European Society. These are incredibly important spaces. And I was really inspired by the energy of all those women there this morning. So I think it's a wonderful time in terms of ideas and fruitful, and this amazing willingness to explore the theoretical boundaries, and just leaves us, absolutely shame in the sense of the experimentation and the exciting ideas that these scholars have. But I think institutionally it's very, very tough. And if I can just squeeze in an answer to Erica's question there, has the institutional culture improved? Look, it's institutional culture is just remarkably durable, and this at my great age now, I used to think it was just a question of more women coming into the system, and people used to say in law schools, as soon as you've got 50% of women students, you just watch 20 years down the track, all the professors, there'll be 50% and so on, and yet we see that is absolutely not the case. So obviously there are more structural and deep barriers that are there. And I think it's uncovering those and really challenging them. And for example, one of the discussions we had this morning was over the idea of merit. If one continues to define merit as an academic completely in the terms of a male life, or merit for judicial appointments, merit and so on, for all these things, if we've always got to keep a close eye on what people mean by merit, and often selection committees or voting committees will have an idea of looking just like us, that's merit, us 20 years ago. So I think we have to keep plugging away, and the wonderful moment that I thought would have well and truly arrived by this stage, I think we're still struggling for. But you take all the tough ones.
I would just add about institutional culture, of course, that institutional culture has changed so much generally over the last 20 years or longer, with sort of so many more demands, such as having to get funding, find various research grants and so on. And so all of these various hurdles that get added to academic life in general, which I'm sure we're all very familiar with, there are the gender dimensions to all of those. And so that is an added issue. State responsibility, Philippa's question. State responsibility, gender equality through the lens of state responsibility. I would just say it's a straight human rights answer. Standard non-discrimination under all the human rights treaties. We've got a great deal now of jurisprudence from the CEDAW Committee, which is very clearly indicating state responsibility for failure to take account of women's human rights, normally under Article 2 of the CEDAW Convention, which is, of course, the general condemnation of discrimination. So it's been flipped, I think, to the sort of prohibition of discrimination, but clearly the goal of that is the gender equality. And I think what we've had as well, very clearly from the CEDAW Committee, is the inclusion in the notion of gender equality, the importance of tackling gender stereotypes under Article 5 of the CEDAW Committee, and that elimination of gender stereotypes is another way which is important for achieving gender equality, and failure to take account and introduce measures to tackle gender stereotypes is also a violation of the Convention. And we're seeing that with respect to activities of law enforcement agents, for example, particularly in the Inter-American Court of Human Rights, with respect to failure to recognise domestic violence for what it is as a gender equality issue, and therefore incurring state responsibility, a whole number of sort of areas like that. Isn't the fact that the SDGs is a temporary project part of the problem? I mean, isn't there a very great danger that, yes, we'll have these indicators and so on, and then at the end of 2030, when we get there, right, gender equality has been done now. And whereas the perpetuation of the importance of the human rights norms, I think it gives that longevity and entrenches it in the context of state responsibility. And I'm just making a sort of couple of other points on that. And I think one of the real pluses of the SDGs is precisely that they are not just targeted at countries that are starting, but are targeted at countries like this country. Gender equality is not just about over there. It's about here. It's about here now. And the SDGs make that clear, even if governments try to pretend that's not the case. Secondly, I think that it's very noticeable that now money, projects, etc., are all geared towards the SDGs and away from human rights. And that was part of my concern. But thirdly, everything that the SDGs do is, I mean, we've got temporary special measures included in the CEDAW Convention. We've got it in the Peoples with Disabilities Convention. It's part of human rights law. And so if what we're talking about is we need particular projects, particular objectives towards achieving the SDGs, we could have done it all already anyway by elevating those elevating the human rights type framework. Demilitarization, yeah. I mean, this has been a goal of the women's movement since at least 1915, when the women met in The Hague at the Women's Congress in 1915, where they made two very clear statements. War can never be good for women. Everything that we're seeing now in WPS and so on is how to make war better for women. Well, why don't we start at that basic first point? War is it's never good for anybody, but it's certainly not good for women. And secondly, what they called for in 1915 was disarmament. Well, what we've seen sort of since then, and I think this has been very much within the Women's International League for Peace and Freedom, and the campaigns that they've carried out and working closely with people like Radhika, are these different strategies, and I have to thank one of my colleagues here for laying these out recently, but we have the disarmament strategy, we have the regulation strategy, how to regulate the use of weapons, and what we had very strongly in the early years of the 21st century was, of course, the humanitarianism strategy, to point out the just inhumanity of weapons. So we had that particularly the Landmines Convention with the Cluster Munitions Convention, and very much as part of the debate around the General Assembly's convention with respect to nuclear weapons, that there is no other basis in which to really make the nuclear argument except the inhumanity of the idea of any such weapons. So the language is out there, the strategies are out there. One of the questions, I suppose, for us as feminists is which of these strategies is the most effective or the most feminist? You know, which should we be actually actively trying to pursue, or all of them added together? Should we try and look at the militarization from all of these different fronts together and try and address the whole issue? Tie it back up to Hilary's last point. We're in a very bad time for all of this. But again, feminist campaigning. The report came out last week, the week before, on what is happening in Yemen, the Commission of Inquiry in Yemen. They make very strongly the point that the sale of weapons to Saudi Arabia is having clear violations of IHL impact in Yemen. As feminists and as campaigners and activists, isn't this something that we all need to be taking on board?
Well, on that note, very important thoughts to leave with us, and we're so privileged, I feel very privileged that Christine and Hilary came here and shared these insights with us, and also we have an opportunity to congratulate them on the 20th anniversary of this seminal book, which is available at a discount price for the next 24 hours.
When we wrote it, we had children. Now we have grandchildren.
Right, grandchildren to support. Thank you both.